Morning. Our next case is Wardson Construction, Inc. et al. Versus City of Raleigh. I'll note that Justice Berenger is recused in this case. We'll hear from the appellant.
Thank you, Your Honor. Good morning, Mr. Chief Justice and Associate Justices. I am Robin Tatum from the firm of Fox Rothschild, and with me is my partner, Kip Nelson, and Carolyn Bockel, who is a Raleigh Deputy City Attorney. We represent the defendant appellant, City of Raleigh. By this appeal, the city is asking the court to reverse the decision of Wake County Superior Court Brian Collins to certify this lawsuit as a class action. We contend that the plaintiffs did not meet their burden to show the legal criteria that are necessary to establish a class under North Carolina law. Specifically, that test requires the plaintiff to establish that the named and unnamed parties share a common issue of law or fact, and that that issue predominates over any issues with respect to individual class members. It is the city's position that it was not met in this case because the record evidence shows that some class members were not financially harmed, yet they will be provided with compensation, and other persons who are not in the class and were harmed will not be compensated unless they find out later that their payment was made to someone else and they file a separate lawsuit in the future. That is the very antithesis of the purposes of class actions. And Chapter 160D, which is a consensus statute that was enacted to consolidate existing and established zoning and land use law, does not change this and has nothing to do with class actions.
So why is this, in your views, a question that impacts the class certification criteria? If as I understand what we're going to hear from the plaintiffs is that the named plaintiffs and all of the putative class members paid a fee that was illegal, and that was the harm, and that they want the money back. So why is the question of whether or not, in fact, that the remedy is to return the money part of the class certification analysis? I mean, isn't that a merits question?
I agree with you 100%. How we got here is, I think finally what happened was it came out in discovery that there is a class member who has suffered no damage, and that is Pro Construction. And what the evidence says, the undisputed evidence, is that the city of Raleigh paid them $50,000 to reimburse them, and they're in the class. So what we know is they're going to get paid twice. Now, their remedy to that is that we can sue them later after we've already done a class action for 7 years and use ratepayer money to go and get the money they never should have been paid for, to begin with. Now, also, the record shows that we have an expert witness and the construction manager for the city of Raleigh that said that's not really unusual, okay? That is how a lot of construction contracts work. And so our position is, you haven't provided us with a class that meets the class requirements because we don't know how many people actually suffered a harm and who didn't. Now, what the appellee's brief now says, and it's pretty much for the first time, that none of that matters. You can pay people twice and you can have litigation spinning off of it because 160D changed the law to allow that to happen. I do not believe that to be the case. It is our position that 160D doesn't have anything to do with the class certification. It was never part of that statute. It was never intended to be a part of that statute. And I'll get to that in a minute.
But I guess, so put that statute aside for a minute.
Right.
Is it your position that some of the putative class members did not pay the fee that the city charges?
I guess the question is, what does it mean to pay the fee, right? So if it means paying the fee, means you just take it over to the city, which is what the plaintiffs allege, and they allege that 160D106 says all you got to do is carry it to the city, so therefore it really doesn't matter if you've suffered any damage because the legislature has somehow said that that's okay. We don't agree with that. What we do agree with is the fact that if you are out of pocket, if you have not been compensated and you're entitled to it, then you're the proper person to recover the money. And if that's the case, and the evidence is as it is in this case, which is we know at least one person is going to get paid twice and probably a lot more, that it's just not a class action, that is not the proper mechanism to bring this forward, and that bringing 160D106.
So help me understand, which prong of class certification does that defeat?
I think the predominance factor, this court talked about this recently a couple of months ago when you decided the Home Depot case, where you're saying that if you have to figure out how each class member was actually injured, if at all, and then calculate their actual injuries, if at all, could cause a case to degenerate into a series of individual trials for each member.
In this case, we think the injury was being forced to pay an illegal fee in order to engage in their business activity.
I think
then it seems to me that the question is whether there are some, at the back end, there are some members of the class who, if you're right about your theory, could not recover because they already had recovered. What I'm trying to figure out is where do we put that in the bucket of the class certification criteria?
I think the issues for individual class members overtake the class action mechanism, because you have to go to each, what our expert testified to, and the same with Priscilla Williams. The only reason we know about this is because we are the city, and so we know what our contracts say, and that is if you're doing work for the city of Raleigh and we're paying you, you go pay the fees and we'll pay you back. So the way that acts out on the ground is that we're actually entitled to the money back, not pro-construction. So under this theory, we give it back to pro-construction, and then we sue them to get it back when we've paid them the second time with interest. And so that is not conducive to a class action. So if you don't know everybody you're paying has suffered an injury, and what our experts said was that it isn't uncommon for this to happen. And the only way that you can know who's actually damaged financially is if you look at each individual contract.
But I guess what I was getting at is what you just said to me sounds more like a superiority argument, that it's not efficient to do this as a class action, have people come in, rather than saying it doesn't meet commonality because there's a predominance problem or there's an ascertainability problem or anything else. And if it's the challenge for you, I think, is if that is the argument, this is not the efficient way to handle it, that we have said that is the prong that's reviewed for abuse of discretion, the ultimate decision there. And it's hard to see the trial court's ruling here as being manifestly arbitrary. I think the court was considering these and nevertheless determined that you could certify.
And we believe that there is no class under the definition because people have different injuries, and you're going to give a lot of money to a lot of people who aren't entitled to it. And that doesn't have anything to do with it being, we don't think it's efficient. And I can get to that a little bit later, but I do think it's a question of law, like in Jackson versus Home Depot, because what you're saying there is there's got to be a bunch of trials to determine whether there was inducement or not. Here, you've got to look at a bunch of contracts to determine whether you're entitled to it. And to me, it's worse because they have come out, my friends have come out and said, it's fine to have a bunch of trials later. You know, we're just going to give the money out to whoever paid it and we'll go on our merry way. And then you figure out later from all of these separate trials who gets the money. And what that is you're going to wrongfully distribute the money and then figure out after the class action is over who was entitled to it. And that does not sound like a proper class to us. That you really need to do a lot better job, in our opinion, with defining your class. And these facts were known. This case has been going on for a long time. discovery was from the summer of 2022 to 2024. Discovery revealed that we're giving you a list. We know at least one person on that list has been reimbursed and should not be in that class. We know that's a common practice. We know that the named plaintiffs testified, we don't know what anybody's business practices are except for us. We only know what ours are. We didn't get the money back, but as to them, we have no clue. One of the named plaintiffs actually did testify that if you've been reimbursed, you shouldn't be able to be reimbursed again. So I don't think that's their purpose. And I don't think adding people to the class that aren't entitled to recover furthers any purpose except expanding the amount of money that gets distributed later. Now, I'm going to turn a little bit now to 160D because we don't think 160D has anything to do with class actions, but we're at a point now where the plaintiffs have said in their appellee's brief the only dispute for class certification purposes is whether General Statute 160D 106 entitles the class members to a refund. So that is their argument. I don't read their argument to say we're claiming that everybody has the same injury. I read that to saying even if they don't have the same injury, you can certify it because of 106, and that's not correct. I want to talk a little bit about 160D. It was a complete reorganization, consolidation, and modernization of a city and county zoning and land use laws. Mainly, it deals with development approvals and development regulations. It was initiated in 2013 by the Zoning, Planning, and Land Use section of the bar. It was not a legislatively initiated undertaking. The Bar Association and our section, the ZPLU, came to the General Assembly and said, please let us do this, and we will draft it. Now, our friends have cited this book as authority. It's called 160D, a new land use law for North Carolina. They say that a footnote in that book, and they say this in their brief at page 33, that it clarifies the recipient of the refund at note 56. They say that the foremost authorities on land use have drafted this book and it supports their position, and it does not. What I want to do is just go to a couple of parts of this book and what it says, and you're, of course, the decider and the legislator enacts it, but I was on that drafting committee. There were 4 people, and I was one of the people who wrote the foreword to this book, and I spent 5 years of my life on it. And what it says over and over again, that this was a consensus bill. In other words, what we were doing was recodifying something, and this actually describes it pretty well. The 5-year undertaking, Herculean in hindsight, was always transparent and inclusive. From the beginning, drafts were routinely circulated among section members, city and county planners, developers, city and county attorneys, private attorneys, and various development groups. Updated drafts were posted on websites, and this is what's important. Consensus changes were included while problematic and controversial changes were not. That is also in the part of the book that talks about consensus. It says, if any reviewers objected to language that changed the meaning of the regulatory authority, they took it out. Same thing again in the section that talks.
There's a lot of textualists on this current court. I guess my question for you would be in subsection 106, when it says that the refund of the fee goes to the person who made the payment.
Yes.
Why wouldn't we just take the ordinary meaning of that term, even if you passed on a cost down the line to someone else? Sort of the person who actually is the one who shows up and says, here's the money, is the one who made the payment, and then there's other people, may just be people who had it passed along to them. I mean, that seems to be an ordinary English usage, what that means. So what do we do with that?
I don't think it's, I respectfully disagree. An example I can give you, last Friday My colleague Catherine comes in my office and she says, I'm ordering lunch from Uber Eats. Do you want something? Oh, yeah. Okay, so I order it. I put it on. She pays for it. I pay her $16 later. Who paid for my lunch? Did Catherine pay for my lunch or did I pay for my lunch? I would say I paid for it even though she delivered it. Another
Yeah, but to take your example, I think that, because I think it's useful here, is but from the perspective of the restaurant, your colleague paid, and then you and your colleague had sort of a separate contractual arrangement where you paid some of the, that money was paid by you, but from the perspective of the, the restaurant, which here would be the city of Raleigh, who were the people coming in and saying, here's the money, and it was these developers that, it seems to me, are the putative class members.
Well, it could be anybody, actually, in reality, in the city of Raleigh. You have, if you look at the list, you have one person who came, 25 times for one company, and that might be their controller or whoever it is. The fact is that list does not match who should be compensated, and we do not believe that it was the intent of the General Assembly when it drafted 106 to give money to people who weren't entitled to it. And if it had been, and I can tell you the footnote that everybody's talking about that says it clarifies who's the recipient of the payment. If in fact all of these stakeholders out there had read that footnote to mean, okay, what this footnote is telling you is you give money to people who paid it even if they're not entitled to it. We're changing the class action rules. You don't have to really prove that you're damaged anymore. And by the way, it's going to spin off a bunch of side trials. If the footnote had said that in the annotated 160D that was sent to the world, I can guarantee you it would not have been a consensus change. Nobody thinks that's what it meant. Nobody thought that was what it meant, because nothing went in that statute unless everybody agreed on it. So now we're coming up with this new theory that I can say I don't think was ever considered, much less consensus. What I believed happened, and this is of course something you can take with a grain of salt, is I don't think that anybody thought about that the person who's actually delivering the payment wasn't the person who was out of pocket until this case came along, at which time it's like, oh my goodness, maybe that's not the best way to do it. But
Let's go back to your hypothetical. Let's say that it was pointed out by you or one of your colleagues that the person was actually charged too much. They were charged an illegal amount for what had been given.
Right.
Could you go to the restaurant and get the refund?
If they paid too much?
Yeah.
No, I don't think I could.
Only the person who paid too much could go get the refund, correct?
Well, yes, I think that's right.
And then it would
but
be
I
up
would
to
be entitled
you.
to it.
It would be up to you if part of your charge was the overpayment. It'd be up to you to go to your colleague that paid for it and got the refund to say, oh, by the way, aren't you going to share with me some of what I overpaid here, correct?
I think that's correct, but I think that goes to the very heart of why this should not be a class action. And that is because the only people who are going to get notice are the people who made the payment. So the people that actually reimburse those people won't know to come and say, can I have my part? We know, because, as the city of Raleigh, because we're the person who paid it back. So in a class action to us is not a mechanism where you give money to people who aren't entitled to it and put the burden on someone who is to come and litigate later.
But doesn't that overlook the fact that you allegedly illegally imposed a tax fee or monetary contribution, and you're not entitled, you, the city of Raleigh, are not entitled to keep that?
And we don't want to keep it, Your Honor. I think the point where we are is we want it to go to the right people, and that we're more than happy to distribute it to the right people. What we don't want to do is have a class action require us to pay people that aren't entitled to it. And so the city of Raleigh...
If the class isn't certified, what steps are you going to take to get the money to the right people?
Well, I don't know that we have any way to do that. The burden is on the plaintiffs to show there is a class. It's not on the city. We know at least one person's going to be paid twice.
Well, if, suppose that we agree with you that there shouldn't be class certification here, but the plaintiffs prevail on the merits, what steps then would you take, having a judgment that says the fees were unlawful? What steps would you then take to see that they're refunded to the proper individuals?
I think what the plaintiffs have suggested is those individuals would file lawsuits
In other words, you're not going to.
I don't think there's a process right now in effect under the class action model for us to distribute the funds to people who weren't included in the class when they were. I can tell you, I was the City of Raleigh city attorney for 5 years. I do not think that Raleigh Water has any desire or indication that they would like to keep money that they're not entitled to, and they would be more than happy if there was a reasonable way to distribute it to do that. So they don't want to keep money they're not entitled to. But on the other hand, is it better to give it to people who aren't damaged at all? And I don't think either one of them is an ideal situation. Now,
So do I understand you that the people, in your view, that are not damaged at all are only those that for some contractual reason that they had with the City of Raleigh, that if they paid a fee to the City of Raleigh, the City of Raleigh would reimburse them? Is that, you said there was one.
That's the one we know about. What we don't.
Well, you're the city. You said you're the city. Why don't you know about all of them?
Because we weren't a part of those contracts.
So your concern is not that these others were repaid. Your concern is that they might not have been the end payor.
It's our position that it's not a proper class when we're reimbursing people who have already been reimbursed, and that a better system.
By anybody?
I think that what the evidence says from the record is that you would have to look at each individual contract, and I think that could have been done.
How many City of Raleigh contracts where there was a reimbursement, how many of those are there?
In this class, one, during this particular time period.
So there's only been one instance where the City of Raleigh can say that we repaid the fund.
Yes, but we don't know if perhaps you hired a contractor to build a house for you.
Why does that matter to you? You're not paying it twice.
Because we don't think that this is a proper class action. It doesn't matter who gets it and who's ultimately entitled. What we do know is that a class action that gives money to people who we know at least one, and perhaps more based on the record, it shouldn't be certified and paid out. We shouldn't pay it out and sort it out later, which is what plaintiffs claim the remedy is. They have now come and said, I think for the first time in the appellee's brief, that yes, we understand there's people in the class that will be compensated twice, but that's okay because they can just file a lawsuit later and get that money back after it's been distributed to the entire class, and even though we don't know who in that class was entitled to it and who was not.
I have a question for you related to your arguments regarding the way that Chapter 160D came into being. And I do understand that your point about it being the product of various groups getting together, interest groups, if you will, for lack of a better term, and coming up with a consensus. But how is that relevant to us? Because the question for us is legislative intent. That's what we're trying to implement, is the intent of the legislature, not of a drafting committee. So help me understand why you think that should influence how we view this.
Well, the question is, what is the intent of the legislature? And I think the intent of the legislature, that they had a bill presented to them by a group, and that when it was adopted, that what this court has to decide is whether the General Assembly intended, when they adopted a few new words at the end of that paragraph that says, you know, the money goes to the person who paid it, did they mean what we assert, which it goes back to the person who has suffered financial harm, or does it mean what the plaintiffs say, which is, okay, this is a shortcut to a class action. You don't have to show you're injured, and we'll go ahead and certify it based on those words and figure it out later. And I do not think that that ever entered the General Assembly's mind, because anything that was ever put before them, nothing ever said that. It was never discussed. So in the intent of the General Assembly, did they mean for 160D 106 to change the nature of a class action? Because their theory, and I've got to stop in a second, is that it applies to all actions. Well, if it's just an action, say, from pro-construction against the city of Raleigh, then we'll move for summary judgment and show we paid the fee. Any litigation between one plaintiff and one local government is going to show really quickly who's responsible. And even under their theory, the person who paid the fee should be the one who ultimately gets the money. You just don't figure that out till later. So because you can't ever really apply their theory to one plaintiff and one defendant, they're arguing 160D changes the law of class actions. And we don't think that was ever the intent. If you can file a lawsuit after the class action is over and you're the injured party and get your money, why should you be able to give it to someone that is not entitled to it in a class action but not in a separate one? I don't think the word class action is never used in 160D. It's not a procedural statute. It just has to do with land use and zoning. I can answer any more questions. Otherwise, I'll reserve my time.
Thank you, counsel. We'll hear from the appellee.
May it please the court, Mr. Chief Justice, Associate Justices, my name is Jim DeMay, and along with my co-counsel Martha Gear and Hunter Bryson, we represent the plaintiff appellees. The issue on this appeal is controlled by the intent of the legislature as expressed in the clear language of 160D 106. It's a simple statute that provides a simple solution and eliminates the issues that the city of Raleigh is trying to interject into this case, and most importantly, make sure that the city doesn't keep the fruits of its unlawful conduct. I'm going to come back to the statute, but first I want to talk about, and Justice Deese, this goes a little bit about your class action questions at the outset to my friend. Let's start with the trial court's order, okay? The trial court found two common issues, which are the same two basic issues that are at issue in this case. Number one, do the fees violate the city's lawful authority delegated by the General Assembly? Yes or no? That can be addressed in one stroke. There's no dispute that the city's fees were applied the same and their policies and practices were applied the same to all class members. And then number two, if the fees were unlawful, whether the city has to return the fees. And that's where we run into 160D 106. But, and Justice Deese, this goes back to your question about the merits, and we're happy to address this issue here on class certification, and we're happy to address it on the merits. But the question here is really, does 160D, I'll say, mean what it says and mean what we believe it to be, is you give it back to the party that paid it?
Did the trial court answer that, enter judgment answering that question?
The
part of the order?
The trial court's summary judgment order awards the fees to the class members who paid the fees. And then if you link that with the class certification order, which references 160D 106. So, and
is that appeal is at the Court of Appeals? Am I right about that?
That's correct.
What's the status of that appeal?
It's been fully briefed. It was on the same track as this case. We have not received a notice for argument yet.
Okay, so I don't know if careful is the right term, but we should probably be aware as we were ruling that what we say, that merits question is being disputed by the parties here in that case. Am I right about that?
That's a good question. The refund issue has not been presented by the city in the merits appeal. They have raised this refund issue, 160D 106, in this appeal. The merits appeal has to do with the legality of the fees in the first place, but they do not argue the refund issue on the merits. But the point is, again, we presented a class, the trial court has certified a class of the parties who have paid these fees. And again, there's no dispute that the city itself refers to them as payors. You can look at the city's responses to requests for admissions, Doc Exhibit 204 and 209. We know their names, we know their addresses. They themselves refer to them as the payors, the parties that paid the fee, complied with the city ordinances to get the permits. And so just to pause on that, this is sort of the paradigm of a class action. I mean, there's no dispute that everybody was subject to the same treatment. And we even have the records, and this is the issue that plagues a lot of class actions. We have the records and the addresses of the parties who are the class members. And so the city's arguments that we've heard today, my friend's arguments, no matter how they're presented, class infeasibility, predominance, conflict within the class, they all get back to the same place, and they all fall apart when you get back to 160D 106. And of course, the court's familiar with the statute, but it says the local government shall return the tax fee or monetary contribution plus interest at the rate of 6% per annum to the person who made the payment. And I want to mention just person is defined in 160D, and it includes corporations, partnerships, ventures. It's much broader than just what you might think of as a person. And I want to mention three things. First, I want to start with the plain language of the statute, because that's, of course, where we need to start. I want to explain why that plain language makes sense. And then I also want to talk about the background of the statute, which can, of course, be indicative of the legislative intent, as well as the acquiescence of the legislature in terms of the implementation of this action in 22 prior identical class actions prior to this case. This case is number 23. With respect to the interpretation, before I get there, though, I do want to point out, I think it's interesting that this statute even exists, right? The legislature could have just said, we're going to let the courts decide how we deal with these refund issues. Instead, it's provided very specific instructions about the refund of these fees. And I think that's indicative, and I'll keep coming back to this, of the fact that the legislature wants these fees to be refunded. They don't want the city to keep them, and a class action here furthers that intent. But let's look at the plain language. Of course, the text of the statute is the best indicative of the legislative intent. Words are to be understood in their ordinary everyday meaning, and the statute says the fee shall be returned to the person that made the payment. When we cite the dictionary definition of those terms, return means to pass back to an earlier possessor, put the money back where you got it, put it in the account that paid you. And to use the Uber Eats example that we just heard about, what's Uber Eats going to do? They're going to refund the person who ordered the food. They're going to put it back in the account. They're going to return it. That's exactly what the legislature is saying here. And I want to pause on that and address the city's injury argument, and where they say, okay, with Pro Construction as an example, because they were paid pursuant to a separate contract, that there was no injury in that circumstance. And two things I want to say about that. Number one, it's wrong. All class members, the payor, were required to comply with the city's, what we contend, unlawful ordinances, unlawful fees to get permits, and paid these funds out of their account. And even using Pro Construction, they paid that fee on September 19th, 2016, and then were paid under their contract with the city on January 12th, 2017. So at a minimum, Pro Construction was without those funds, their funds that never should have been taken from them, for 4 months. That's 100% an injury. But you don't even need to go there, because as this court just recognized 2 months ago in the Jackson versus Home Depot opinion, 160D 106 creates a statutory remedy for the payor. And you can also look to this court's decision in the committee to elect Dan Forrest's case for the same principle, both in the majority opinion.
Yeah, I wanna understand your argument here, because I think you're hitting on something that, to me, seemed an important consideration in the case. So it sounds like you're not asking us to. There's a doctrine from the Supreme Court of the United States, and Walmart v. Dukes and other cases, that has made its way into our sort of class action jurisprudence from DeWalt v. Hooks, and as you said in the Jackson case, that there does need to be a common injury is one of something that's required for class certification. But as I understand your argument, there is a common injury, which is every putative class member was forced to pay an illegal fee. What happens because of that injury would be the appropriate remedy. And it may be that there's slightly different remedies here, but your position is that most that may be that some are getting the money back and then may have to pay it back to someone else. Am I understanding that right? So you're not arguing that that our common injury requirements no longer are part of our jurisprudence.
I'm not arguing that the common injury requirement is not part of our jurisprudence. I'm arguing that the injury, the legal injury created by the legislature in 160D 106 is common to all payors because that's what the statute says and that is what our class is. That is what I'm arguing.
What I was getting at is like, why for that part of the case do we even need 160D 106? I mean, wouldn't the common injury for all the class members be that in order to start their construction, they had to go and pay, or continue their construction, they had to pay a fee to the government that was illegal, and every single one of them had to do that?
I think you could stop there. We're giving you the full circle here, and because
so, like, you know, for example, in the Jackson, if we take what we were discussing in Jackson, for example, we talk about how you have to have for unfair and deceptive trade practice, let's say, you have to have an actual injury. But then there's also the calculation of the damages for that injury. Those seem to me to be two distinct determinations. And here, the common injury issue is the one that your friend seems to be focused on. And there, it just seems like every class member has paid, it claims they paid the illegal fee, and that would be their injury.
Well, I agree with that, but I'm also going to take it further because the common remedy is what the General Assembly said, and that you refund it to the payor. And I'm going to get to the reasons why that makes sense in a minute, but it's a common injury and it's a common remedy. I would submit that you couldn't have anything that's more common than what we're presenting and what we view as a paradigm of class action here. But getting back to the plain language of the statute, the last thing I want to mention is that the statute was a clarification, and you know, it's the intent of the legislature, whether you want to view it in terms of the intent of the consensus committee or the legislature, whatever. It was a clarifying amendment, and those words to the party that paid, or to the person who paid the fee, were added from the former version of the statute. So if you were going to accept my friend's arguments and say, well, we need to look beyond the transaction with the city and look at these other things, the statute would be just as open-ended as before. Those words would be superfluous. And of course, we're supposed to give an intent and meaning to all the words in a statute. But I want to switch now to the reasons why the intent of the statute makes sense, or the plain language makes sense, because I think what my friends are really arguing here is not that the plain language doesn't mean what it says, but that it would create what they view to be an absurd result. And of course, as this court just recognizes in Jackson, we don't question the wisdom of the legislature, and we don't consider the statute's plain text absurd just because we might be able to imagine a different alternative. But the statute makes sense, and I want to address several reasons why it does. And first, most importantly, it ensures that the cities pay back illegal fees by providing a certain identifiable refund recipient. This avoids the issue, like the city is raising here, like the town of Carthage tried to argue in the Quality Built Homes case, that there's some ambiguity in terms of the refund recipient to then be able to keep these fees. By providing a precise recipient, it avoids those problems. In the same light, it also, if you're going to engage in the city's sort of analysis of this passing on, it avoids the uncertainty of the payment of a fee in a market setting. Their own proposed expert says that the fee is passed on each time the home is sold. So you're going to look at this, the second purchaser, the third purchaser, the fourth purchaser. Does the fee need to be a seller credit on the HUD every time a home is sold? Or you could look the other way. You could look at the landowner who sold the land to the builder, who may have received less for the land because it was going to have this tied to the development cost. By providing this instruction in 160D 106, we provide a clear recipient of the fee to make sure that the city doesn't keep its illegal receipts. Along those same lines, second, the statute provides a benefit for the city, because before all those reasons that I just recited about these different people who could come forward, all those different people could come forward with claims against the city. The statute provides, again, with this clear, precise recipient, it avoids those issues. And then third, it keeps with prior judicial precedent. This court, and we've not heard the city respond to this in the briefs or today. This court rejected the same argument when it was made in the context of an estoppel argument in the Quality Built Homes versus Town of Carthage case. There are other precedent in our state. You can look to the Court of Appeals decision in the Point South Properties case, the Durham Landowner School Impact Fee case, the Amward Homes case, School Impact Fee, China Grove 152, Adequate Public Facilities Fee. In all those cases, the fees were refunded to the direct payors. So it keeps with the law. And then the fourth point I want to point out is the statute, and I'm responding to the arguments that were made in the brief about the suggestion that if a builder makes a profit on a home, that the fee is passed on in that profit. And I'm speaking from the deposition testimony of our clients, but that's just not how home building and land development works. Do we try to make a profit? Absolutely, 100%. But our homes are set to the price of the market, okay? And that market price is set in comparison to existing homes that don't have this fee attached to it. It's set in comparison to homes in neighboring jurisdictions that don't have this fee attached to it. So if we make a profit on our home, our profit is reduced by the amount of the fee that we pay. By contrast, if we have a loss, which is in the case of a couple homes that our clients built, then that loss is exacerbated by the amount of the fee. But either way, in that context, it's the payor, the home builder, who is damaged. Now, you have, these separate contract issues where the city has pointed out one, and there's this belief that, Pro Construction, for example, is just going to abscond with this money. They have a separate contractual legal relationship, and if they're required to pay it back, then they have to pay it back to whoever the third party was. But let's compare that versus, the issue in terms of the windfall to the city if the city doesn't have to refund these funds at all. So getting back to my original point, 160D 106 avoids those problems by providing a clear, precise refund recipient, which is the payor of the fee, which is not in dispute in this case. The final point I want to make is regarding both the background of the adoption of the act, as well as what I would view as the acquiescence of the legislature in terms of how the act has been, or the law has been implemented. This case, of course, follows from this court's unanimous 2016 decision in the Quality Built Homes case, which held that absent specific local act authorities, cities lack the power to charge water and sewer impact fees. The next year, the General Assembly enacted legislation allowing cities to prospectively charge these fees, but subject to very precise restrictions and limitations. But they took what I would view as an interesting step. They expressly provided that the past fees that were charged were not retroactively authorized. And they also enacted an express 3-year statute of limitations for parties to sue for the recovery of these fees. So I mention that just because I think that's further intent that the legislature did not want cities to keep these fees. Then we have the next year, 2018. We have this court's second decision in the Quality Built Homes case, where this court rejected the passing on argument that the town of Carthage made, but didn't do it in the context of this statute, did it in the context of rejecting their estoppel argument. And that's at page 66 of the Quality Built Homes opinion. And then we get to 2019, when this statute was clarified. And because this issue had been raised in Quality Built Homes, and because this issue had also been raised in a prior water and sewer case, the Point South Properties case, the General Assembly put those issues to bed and said, this is who gets the money back. It's the party that paid the fee. I think what's more important than that even is how the General Assembly has acquiesced to how the statute has been applied by courts since that time. As I mentioned, this case is, it follows from the Quality Built Homes litigation. There have been 22 other, what I'll call post-Quality Built Homes, water and sewer class action refund cases. And all 22 of those cases, they're in the record, classes have been certified identical to this case, a class of payors, the parties that directly paid the fees to cities. You have the Dallas versus City of Charlotte case. That was a case that went to the Court of Appeals, was affirmed on the merits for the plaintiffs. City of Charlotte refunded fees to a class identical to here of payors. The True Homes versus City of Greensboro case, same thing as the City of Charlotte case, affirmed by the Court of Appeals on the merits, refund to a class of payors. A number of other cases. And then in addition, 2 cases that went up on class cert to this court, the Plantation Building of Wilmington versus Town of Leland case, that didn't involve this refund issue, but it was a water and sewer case identical to this, a class of payors affirmed. And then the Zander, the last point I'm going to mention is the Zander versus Orange County case, which was a school impact fee case, not a water and sewer case. But again, this court affirmed certification of a class that had that was the parties that paid the fee, just like here. So all that to say, if the General Assembly didn't like how this statute was being applied in terms of certification of classes of parties that paid the fees, they've had 6 years now to do something to change it, and they haven't done so. And I think that speaks volumes about their intent. So unless there's any questions that the court has, just in closing, just sort of bringing this back to the class action, here we have a known class of specific parties, the parties that are identified by the General Assembly in 160D 106, who paid the fees. They have a common interest in having the fees refunded under the statute, and the trial court was manifestly correct in certifying the class in this case. So we would respectfully request that this court affirm the trial court's order certifying the class. Thank you.
Thank you, counsel. Rebuttal.
Thank you. Just a couple of points. As my friends have said over and over, we're the last quality built case because the statute of limitations has run on all of them. That case was decided before 160D ever came into effect. So the consequence of this decision applies as far as water and sewer quality built claims just to the city of Raleigh. But if you look at the statute, it applies to every illegally imposed tax, fee, or monetary contributions for development or a development approval. That is a huge bucket. It is every school fee, subdivision fee, stormwater fee, electrical fee, building permit fee, fee in lieu. So what this decision does, which our opinion is it's not a class action statute. You don't even look at 105 until you've determined that there's a class, or not, because it applies to both. But going forward, what this is saying for all of those fees is that they're an automatic class. The person who paid it gets it back. It doesn't matter who's out of pocket. And if the wrong person got it, then you'll have a trial later. A common question doesn't necessarily mean that there is superiority and feasibility as well. So even under their theory, the right person can have the money, they just have to litigate later. And that is exactly what the class action process says should not be. I do want to talk about the Zander case. That case was reversed by this court because they found a question of fact and remanded it back. But that's the only case in the appellate courts that have ever discussed the meaning of 160D 106. And in that case, the plaintiffs argued that even though part of the fee was legal and part was illegal, they got all of the fee, and the court said no. And this court didn't address this, and I'm not saying it's binding, but I do think it is an interpretation of that statute that at least one appellate court has made. And they said no. 160D 106 is designed to make plaintiffs whole for legal fees. Nothing in the statute suggests it is intended to punish local governments while granting a windfall to the plaintiffs, and that would be an absurd interpretation. The city of Raleigh has no desire to keep money it is not entitled to. However, under the class action statutes in 106, that does not mean that you give it to whoever shows up and has carried some money to the city. You want to get it to the people who have been properly injured. And we believe that the class action model is not workable for this particular case. And let me say, all of these other cases that have been certified, this issue has never been raised until this case. No court has ever decided it. And so if they were certified, that was on the basis, which I think probably the legislature thought, is whoever takes the fee probably is entitled to get it back. We know now that does not happen here. So whatever happened there, that's fine. I think any change to this should be a legislative change that is vetted and understood, and everybody knows what the question is, and that there should not be a decision that this basic language made this gigantic change to class action law without anybody really knowing that they did it. So thank you very much. I appreciate your time.
Thank you, counsel. Mr. Clark.
Oh yes, oh yes. The Supreme Court of North Carolina will be in recess for 45 minutes. God save the state.